Welcome everybody to this edition of the Singapore Convention Mediation Series, brought to you by IMI as well as our friends at the Singapore International Mediation Institute. For those who don't know me, I'm Laura Skillen, the Executive Director of the International Mediation Institute. And just before we get started, a little quick housekeeping. For those of you who haven't attended a webinar on Zoom before, you'll find there's a little Q&A button at the bottom of your screen. So if you do have questions, either during the presentation or afterwards, please do put your questions in there, and that way we'll address them once the presentation is over. Brilliant, but with no further ado, I'm going to introduce Ban Jiun Ean, who is going to be talking to us today about how the Singapore Convention will move the needle in the mediation market. He's the Executive Director of the Singapore Mediation Centre, and we are very happy to have him here with us today. Jiun Ean?
Thank you, Laura. Hi, everybody. Before I start, full disclosure, before I joined the Singapore Mediation Centre, I spent a lot more time on the other side of the fence, helping to develop the arbitration industry. So I kind of understand the pain that people feel sometimes when they always seem to be compared poorly with arbitration. And that's actually a good way for me to just segue into the main topic itself, which is the fact that we now actually have a convention that can sit right alongside the New York Convention for enforcement of mediation agreements, which I think actually for a long time people have been asking for some sort of international enforcement mechanism. But what I really found interesting was the conversation that surrounded the convention itself was a lot broader than just enforcement. And I think a lot of it had to do with perception. A lot of it had to do with the way mediation was either not very well known or not very well regarded among businesses and even among legal practitioners, which is quite surprising actually, that even in this day and age, you have dispute practitioners who still don't understand mediation. They think it's just arbitration with even more flexible rules. But I think this convention is actually a very important step forward in many respects. So let me just start by saying the key difference before the convention and after the convention is, of course, now we have an instrument that allows you to enforce your mediated settlement in another signatory country. So just by way of update, in case people are curious, as of now, there are about 51 countries that have signed the convention, and we required 3 countries to ratify it before it would come into force. 6 months after the 3rd country ratified it, it would come into force. And on the 12th of March, the 3rd country, Qatar, actually ratified it. The first 2, of course, was Singapore itself and Fiji. So in 6 months' time, that will be the 12th of September, this convention actually goes into force. Of course, we expect that it will take a while for the other signatory countries to ratify, because depending on their own political systems and the need for having the laws that are harmonized with their own legal systems. And of course, the world that we live in right now with this global pandemic, it's going to also put a bit of a spanner in the country's focus right now. But I think we can look forward to a point not too far in the future when there will be many signatory countries and ratified as well. So you can actually take your mediated agreement and enforce it in the countries around. So that's I think the first and obvious benefit of this convention that will help the international mediation industry. It actually provides that baseline foundation for you to be able to go and enforce your agreement. But what I actually want to focus on is actually go beyond that, because that's actually the easy part of the conversation. You can actually go and look at the text itself. You can go and look at whatever on UNCITRAL's website. And right now, in fact, they're coming up with the model rules for people who want to basically put in their settlement agreements, their contracts, that if there's a mediation, it will be conducted under the UNCITRAL model rules. So that's in progress right now. But I think that's an easy part. You can go and look at it and try to understand it. The takeaway is simply that signatory countries can have their mediated settlements enforced in each other's jurisdictions. But actually what really I found interesting was the fact that the existence of a convention and the fanfare surrounding it, especially last year at the signing ceremony, where an amazing number of countries came to sign on the very first day, 46 countries. I mean, we now take the New York Convention for granted, but we forget that it's been here for decades. It started off slowly as well and eventually began to gain some momentum. But the Singapore Convention had 46 signatories on the very first day. And that's not even counting some other countries that failed to make, what we actually witnessed for us in Singapore at the ceremony itself. We actually had countries rushing to try to get into the signing ceremony on the morning itself. I had a story from someone where the Prime Minister of Singapore was actually walking in for the ceremony, and there was a diplomat from another country that was at that moment still trying to get into the signing ceremony because the authorization, the credentials came so late from their home country that they couldn't tell us until that morning itself. But unfortunately, they didn't make the signing ceremony. They had to sign it a bit later. But it shows that there was quite a lot of interest at the moment. And of course, it's not just all credit to the mediation community itself. I think the New York Convention itself created an understanding in people's minds as how powerful an instrument of that sort could be, how effective it was in helping to enhance global trade and dispute resolution. So I think there was a lot more comfort for people to sign on to the New York Convention equivalent in the mediation industry. But what that also generated was a lot of interest in mediation in general. It created a lot of conversation. It created a lot of people starting to sit up and say, hey, what's going on? What is this? Why is everyone suddenly so interested in it? Why is everyone talking about it? And it gave us at least a couple of benefits that we can see around the world. The first thing I think I'll say is that it galvanized a lot of the mediation communities around the world. People who, for a long time either, practiced it in a very sort of insular manner where they didn't really work with one another, they didn't really talk to one another, they were just more concerned with their individual practices. But because there was a national effort that they were trying to move, to say, hey, can we lobby our government? Can we lobby, our trade or our, economic ministries to sort of sign on to this? Or maybe we need to lobby the judiciary and to help them understand what are the implications if you now have to enforce mediation settlements from overseas and stuff like that. So they began to have this movement in various countries, started to see people come together and collectively try to lobby the governments, try to explain and educate government officials about why this was important and so on and so forth. So that's a very important step forward. And it also strengthened the hand of advocates, people who always been trying to promote mediation, trying to encourage parties to take it, to use it, to talk to businesses and even law firms to say, look, this is something which you should take seriously. This kind of dispute, it's tailor-made for mediation. You should really try it. But because people tend to avoid, they're not familiar with, people tend to stay away from something where they don't think they'll be as good or effective in that arena as they are in some other arena. They tend to steer people to where they are experts in, where they're good in. So that always left mediation in a very difficult position where those who understand mediation know that this is probably the best way forward, that you should at least give it a try, especially the fact that going for mediation doesn't preclude you from going for your other forms of dispute resolution after that. You can still go for arbitration, you can still go for litigation, but if you don't give it a try, you won't really know how you could possibly have saved weeks or months of being sort of trapped in a big acrimonious legal proceeding. So that kind of voice has always been sort of downplayed by people saying, no, this doesn't really work as well as you think it does. We'd rather just go to court, we'd rather just go for arbitration. So the convention itself has strengthened the voice of these people and has galvanized the communities. I remember Tim Schneider actually said something interesting from one of the panel sessions at the convention conference itself, where he said that one of the things that the working group kept hearing from people who were keen and very much promoters of mediation, but they were trying to persuade their own principals or their own, managing directors, their own boards of their companies, that they should put in a mediation clause, there's always the retort to say that, well, mediation, I can't, first of all, I can't compel the other side to come. Secondly, I can't, make the other side come to any kind of reasonable agreement. They could just dig their heels in and we'll just be wasting our time. And finally, even if we got them to have a settlement agreement, what's the point if they don't want to comply with the obligations that they agreed to? They get on a plane, they go back home and they decide, just tear this up. What happens next, right? So why bother? That has always been a big problem at the stage of trying to even convince your own companies, your own lawyers to put mediation clauses into international contracts. And so one of the things that the convention actually sort of helps with is it now gives teeth to the mediation agreement and sort of allows you to address that particular question, that particular objection head on, to say, look, see, now we have these mechanisms, we have these tools, we have this protection. So can we put this mediation clause in? And for those of us who are, in the mediation world, we know that actually the point where you require some kind of compulsive mechanism for ensuring compliance of the other side, that's actually the worst case scenario. You don't really want to get to that point, and you shouldn't. In fact, most of the cases that end in a mediated settlement would probably end up having both parties voluntarily comply with what they've agreed to. Because first of all, again, if you do a mediation correctly, parties shouldn't feel coerced into the settlement agreement. They shouldn't feel that what they've agreed to on paper wasn't really what they wanted to. That shouldn't happen. So in a properly conducted mediation where parties finally come to some kind of meeting of minds and say, okay, fine, let's just draw a line under this whole saga. Let's put an end to months and months of this. I need to focus on developing, my business. You need to focus on moving forward. Can we just wrap this up once and for all? When they come to that agreement, it doesn't really make sense that they would then go back and then restart the entire process of fighting again when they've already sort of brought the other side to the table and found some common ground. Most parties would then try to comply with what they agreed to, because that's actually one of the greatest strengths of mediation, that you have a process in which it's not adversarial. It's not winner take all. It's not a kind where whatever I get probably leaves you with less, and we after that struggle to even talk. We don't want to work together anymore. We don't want to do business. All these things, you try to avoid that by going for mediation. So why would you then ignore the terms of the settlement? Why would you then go back to the point where you have a fight? So I actually think that the need to use the convention, the need to actually have teeth behind it, is actually only for very rare situations. For example, parties, maybe when they go back, they realize that they sort of made a bad mistake and then they change their minds. That hopefully doesn't happen too often. Or maybe the compliance or the execution of the obligations is some way down the road and parties forget. Parties sort of feel, hey, why did I agree to this? Or maybe there's just a change of management. Whatever you agreed to in the mediation, later on your successor decides, well, I would never have agreed to that. I should never have given away that. So they decide we won't comply. So all those are the scenarios that you could really say, well, I need to be able to do something with this. I need to be able to not have to go and sue the guy in his country again. I can just go and put it before the court and have it enforced. But most of the time, I think the real benefit is for people to actually go through a mediation that is well conducted by an experienced mediator with an open mind on both parties' sides, where they come in saying that, okay, fine, since I'm here, since I got on a plane, made the trip all the way to this place, I'm just going to give it a shot. Let's just see where this goes. And again, like we see globally, the settlement rate for mediations is, 60, 70, maybe 80%. So it means that you're more than likely to actually come away with a settlement agreement if you actually bother to step into a mediation. And that's kind of half the battle won. That's for many people the point where if I can even get my company to agree to put a mediation clause into the contract, if I can even get the other side to agree to turn up for a mediation when a dispute arises and so on and so forth, that's already half the battle won. You don't really need to then use the convention. You don't really need to then activate whatever provisions to then force the other side to comply, because you've already gotten the hard work out of the way. You've gotten the mediation clause and you've gotten people into the room. So I actually feel that the interesting benefit of the convention is that it's such a high signature event, it's such a global event, if you will, that it has catapulted mediation as a dispute resolution tool into a completely different plane. And it now can rightfully sit alongside the more well-known avenues, you know, going to court and going to arbitration and so on. And I think that's actually probably the one that moves the needle the greatest, that conversation surrounding it makes people more willing to give it a try, makes people more willing to put it in as a clause. I mean, for example, in India, the Indians were one of the signatories on the very first day. I mean, you have to think about this. It was quite a momentous event. The people who came and signed on the first day, you get the biggest countries in the world. You had India, you had China, you had the United States signing the same convention on the very first day. I thought it was interesting that you had a photo where you had the representative from Israel and the representative from Iran in the same photo. I mean, that's such a major global event. But it's completely in the spirit of mediation, which is about peacemaking, conflict resolution. So I think that the international signature of the convention is actually the single greatest benefit of it. The fact that now, you know, government officials who never needed to bother with this were forced to take it seriously. People who were talking about it with their you know, their clients or with, you know, the decision makers in their organizations, they can now point to this and say, look, this is a big thing. This is a massive global movement where people are trying to say, let's use this to solve our international disputes, or at least let's give it a shot before we try the other ways. It strengthens the hand of everybody who's trying to move mediation forward. And so that's what actually makes me really excited. Not so much the provisions in there, which are of course very important, but what the provisions allow us to do, which is to actually get the foot in the door to have this conversation about mediation in general. So that for me actually is really how I would look at it, that the mediation industry, the global international mediation industry is poised you know, for a growth in a new way because of the convention. And again, all credit to the team, to the people around the world who worked so hard to hammer out the text of the convention. But really, the convention's wording itself is only part of the equation. It's really the fact that it has been brought to a different level of prominence internationally that is real, to me, the real benefit. And it becomes a lot easier now to persuade people. It's a lot more, you know, it's a lot more mainstream now, if you want to describe it in a sort of a single word, that people can now talk about mediation in a way that they used to talk about arbitration. And I think that's really something that's very heartening to look forward to. So yeah, I think my 15 minutes is up. Laura, do you want to jump in here?
Yes, that's perfect. Thank you very much for that, I think, interesting and succinct and just beautiful presentation. So you'll see we've had some questions coming in. So if you want to tackle a few of those, perhaps.
So I've got a question from Marcus at the start, which is, will you be able to share the number of mediation cases that take place in Singapore in 2019? That in SMC itself, a Singapore Mediation Centre, we have about 450 cases last year, and they are primarily commercial disputes. There is a proportion of them which are cross-border, but in Singapore, the definition of a cross-border case is extremely complicated because Singapore is a very small country. So for something to fall outside our borders is very, very easy. We're so tiny. But we also have a very, very large number of international companies that are based in Singapore. Either their global headquarters are based in Singapore, or their regional, their Asia Pacific headquarters is based in Singapore. So when they run a dispute out of Singapore, it may look domestic because both parties have a Singapore address, but it actually concerns a dispute that happens outside Singapore. So I would say that we actually have a fair number of cross-border disputes, but they look domestic because both parties that file it have a Singapore registered address. So I would say, I don't know, I would say in the hundreds, in the thousands, depending on what you're referring to, the number of mediations happening in Singapore last year. Okay, so why hasn't the EU signed the convention yet? So take this as my personal opinion, and hopefully it will sit there among the other opinions you've read, and you can just weigh for yourself how much you think this is likely to be the truth or the actual situation based on what I know. So first of all, from the working group itself, I understand that during the working group negotiations and discussions, there was somewhat of a divergence in views between people who felt that they wanted a convention, an international treaty that you could sign on to, and a group that felt that we don't need a treaty, or we shouldn't have a treaty, and it would be more effective to have a model law that people can then adopt in their own countries and modify as they saw fit. And my understanding from the people who were involved in the working group was that the Europeans in the EU very much belonged to the second group, that they felt that the convention wasn't something that they were advocating. They would prefer to have seen a model law come out. Whereas other countries like the Americans who proposed the convention, and Singapore, that was also very strongly backing the idea of a convention, fell into the other camp. So finally, when the convention was drafted, I don't think it's surprising that the EU countries will also be a bit reluctant to immediately sign on until they were clear about the implications of being part of it, and also to look at it to see how it would impact their own EU laws and their existing mechanisms that already exist. And of course, the EU itself, the EU has a whip, so you might have difficulty as an individual EU member sort of unilaterally signing on to an international convention without first having it extensively discussed with other EU members. So there's probably also a little bit of to and froing that's going on within the EU about whether or not they should be part of it as a bloc, or whether they want to just allow individual EU members to decide and to sign on as and when they feel like it. So I think that there's a few factors at play there, but I think that the largest part of it is the fact that there was an initial divergence of views about what's the best way forward, and eventually the view of having a convention prevailed, but many of the European countries belong to the other view, and so they would understandably be slower in wanting to sign on to this. So that's, yeah. What more do you think needs to be done beyond the convention for mediation to be used more frequently internationally? I think actually one of the big challenges is that we need to have a much larger pool of professional mediators, and especially people who come from very different sort of disciplines, from very different kinds of backgrounds, who are able to approach a particular industry with the kind of deep knowledge of that industry, and yet they are also full-time mediators. So people know that they have a certain track record, a certain amount of experience in handling complicated mediations, and yet they are not generalists. They don't bring with them, say, a lawyer's background into a very complicated industry like, say, the oil and gas industry, shipping, aviation, where you sort of half the time you're attempting to understand the terminology, or you have to rely on the expert sitting beside you who is an expert in the industry but may not be an experienced mediator. So you're sort of having two people trying to be one brain together. I think when we really have a lot more international mediators who have that kind of depth of understanding of specific sectors, but yet they also have that credibility as mediators, that they've been doing it for many years, they've mediated really large cases. I think people will have that confidence to say, yes, I know this person and I think this person is the right choice for this particular dispute. And it has to happen over a period of time, because people also have to, first of all, trust the process. And that can only happen if you've actually been through a mediation process yourself. You've seen firsthand what happens in a mediation, how a good mediator can really diffuse tension, can really get parties to focus their minds on what's important and not get hung up by obligations that were not met, and words that were said, things that were done, all these things. A good mediator can steer people away from it to say, look, let's talk about problem solving. So when people begin to understand how powerful mediation is, they become a lot more likely to use it in the future. They become more likely to put clauses in their contracts. They become more likely to agree when the other side proposes mediation. So that, I think, has to happen over a bit of time, and you need good experienced mediators in various fields to be able to push that message forward. Because there's a good chance as well that, when you have a particular individual who's very, very experienced and well-known in a particular field, and yet is a very good mediator, the people in that field will also sort of know this person. You can't gain this kind of experience without sort of working in it for a long time. So people in that field, in that industry will also have heard of you. So that also makes it easier for them to accept mediation because they know who you are. They are more likely to ask for mediation if they know you're the mediator than to ask for some lawyer from somewhere else who's parachuted into this industry to try to understand the conversation in the mediation. Notwithstanding his track record, he may have done huge cases, he may have a great success rate, he may have done a lot of cases, but there's still that nagging suspicion that he doesn't really understand the quirks and the practices in our industry. So I think that's what we need to see next. A lot of people who are very much deep and strong in specific sectors, but yet credible as international mediators. I mean, I've heard of a case where an international mediator settled a case or was in the process of settling a case. There was $1 billion in dispute. I mean, a case like that, people aren't just going to pick a random person. You need someone that they really can trust because there's so much at stake. So I think this is something that goes beyond what the convention can do. The convention at the end of the day is just a text. I think they need to know who is the person that's going to be before them, who's the one who's going to be guiding the parties, especially if the person needs to be someone that you can trust when they have a private caucus with the other side, that they will not sort of leak confidential information that you've told them to the other side so that it strengthens the other person's bargaining power and so on and so forth. All these things, I think, all have to organically develop over time before the acceptance of mediation really begins to take root in a large way. So that's my response to that. What are the impacts on the convention on countries that have not signed it yet? Well, I think I mentioned the fact that it has entered into people's lexicon in a way that was never seen before. People are actually talking about mediation. They're asking about it at the very least, taking notice of it, wondering why 46 countries, including the world's biggest economies, signed on to it. I think that's the first thing, that people have not signed on to it are now a lot more curious about it at the very least, or they're taking it seriously in a way that they never had before. So I think that's the first major impact. The second is, as more and more countries ratify it, now that the convention is going to come into force in September, and more countries ratify it, so more and more countries begin to use it or talk about it, you also get the unfortunate fear of missing out effect, which in our case would be a good thing, where people begin to say, hey, we didn't sign on to it, but it looks like there's some momentum gathering on this front. Should we? Can we afford to be left out? Are we going to have problems when people are starting to put mediation to their clauses, but our companies can't benefit from it because we're not a signatory, so on and so forth. So I think the impact of more and more countries taking it seriously is just going to have a positive knock-on effect to all the rest who haven't signed on. Can you put a Singapore mediation convention clause in a contract where the contract's choice of law clause isn't a member of the convention? Okay, so my understanding of the convention, and I hope I didn't get it wrong, was that it actually refers to signatory countries and the location of the mediation, where it took place. So that's kind of tricky because it really doesn't matter, I think, whether you can put a clause in the contract or whether you can say the choice of law is Singapore, because it sort of refers to the location of the mediation agreement, the mediated agreement. So it seems to be more dependent on where you mediate or where you deem the mediation to take place. I think it might be possible to actually mediate in another place and yet deem it to have taken place in a signatory country. That could be one way out. And certainly in this era of COVID-19, you may have to do that because parties are literally not in a particular place and they're doing it online. So where would you deem the mediation agreement to have taken place? But I think you could probably deem that it takes place in a particular place, especially if you mediate under the auspices of an institution like SMC or some other one, which is based in a particular country. Then you could easily say, yeah, that's where the mediation took place, and therefore, because that location, that country is a signatory, I can now avail myself of the convention. But I'm not sure you can just write it in and based on the choice of law, therefore become part of the convention, because I don't think it was drafted to be the choice of law of the contract, but more the location of the mediation, so that the settlement agreement arose from. Sorry, Laura, jump in if I've got my facts wrong in this.
I've just seen somebody's added to that question about the Singapore Convention clause, and they've asked if it applies when the mediation is online.
Yeah, that actually is something which I personally don't know the answer to. I have to apologize that wasn't a question that really came up prior to this recent scenario where a lot more people are mediating online. So I have to actually say that I'm not sure of the answer. It might not even be a clear answer yet. At the point when the convention was drafted, I think that it was phrased in a way that still sort of envisaged a physical mediation taking place. So for an online mediation, that's something which you might find it in the rules going forward, because the rules are still sort of in progress right now. So they may add in portions that address this specifically, and parties can adopt it. But I think the convention itself is not specific about online mediation. Not clear enough, in my opinion, about it. So one of the distinguishing features between arbitration and mediation is enforcement of the settlement in the former method. What is the impact on international arbitration because of this convention? Well, yes, I think if you look at it from the point where if you have this pie of disputes where a portion of them are going to arbitration, a portion of them are going to court, and a portion of them are going for mediation, you know, and naturally the way to look at it would be that if people become more comfortable with mediation, because now it's a lot more enforceable than before the convention, that would come from somewhere, assuming a finite pie, you know, and that naturally means that it will come from arbitration among other parts of the pie. So yes, you can see that some parties who previously opted for arbitration primarily for the enforceability, you might see some of them switching over to mediation because that obstacle has been removed, and they might actually be more comfortable with mediation, but they just were worried about enforceability. So that would lift that obstacle away and they'll move over. So yes, I think there'll be some impact to that. But apart from that, I think we need to be very clear that at the end of the day, people still have to pick the right tool for the job. And there are certain instances where arbitration might be, you know, a more appropriate kind of mechanism. There are other scenarios where going to court is better because, for example, in a domestic mediation, so this is not quite applicable to an international mediation for the settlement, for the convention itself, but let's just use a domestic case just to illustrate something. If you have a case where the parties have a dispute, and the dispute is not about, you know, an issue of fact. Did you in fact deliver on your obligations? Did you in fact pay on time or whatever? But an issue of law. Could I have done this because the law says this, or was I obligated to perform this because of the law? Now you can't mediate that away. You can't mediate and say that let's both agree that the law said this. That's not how the law works. So you may still have to go to court to get clarity. You may need a judge to pronounce an interpretation of a particular statute. So in that case, a mediation would not be the best option for a dispute. And I can imagine that in international cases, there may be that scenario too, where you may need a pronouncement on international law. You may need a pronouncement on international, you know, sort of trade practices. So again, you could technically mediate certain things, but yet you want an answer. You want you know, people to come out and sort of say, well, this is the law in a particular country, or this is a law in the EU or something like that. So so there may be some scenarios where it's not the appropriate tool. But I think by and large, for most disputes, you would find that mediation is the most appropriate tool, or at least the most appropriate tool to start with. And even if you don't finally reach a resolution, you can still go back to your other processes. So that necessarily means that people might try mediation before going for arbitration. And if the settlement rates remain constant at about 60–70%, then yes, you will definitely see a lot of cases that will end at the mediation stage. You won't even go to arbitration, and that will definitely have a knock-on effect on the arbitration industry in a negative way. So that's something for arbitration practitioners to be aware of, but not necessarily a bad thing for the companies, for the clients, because, you know, why would you want to have a drawn-out process when you have a resolution right here and you save money and time? And even for lawyers, it's not necessarily a bad thing to have a settlement, because you might have a weak case and you're quite happy to see it settled rather than you lose. Or you might really feel that this case really isn't something that you want to fight over because there are other things that warrant your attention more, but this is really weighing you down. It becomes very acrimonious and drawn out, and you're flooded with documents, and really both sides actually should just settle. So I think there are many cases where an arbitration case might not materialize because they went for mediation and it turned out well. Everyone pushed for it, the lawyers pushed for it, the parties wanted it, and finally they settled. So that's my take. It will have a negative sort of outcome for arbitration in general, unfortunately. My question regards to process, how mediation and conciliation as a dispute resolution mechanism functions. Won't introducing enforcement concept in the proceedings of mediation create a confusion among the parties as to choosing mediation or conciliation for their disputes to be resolved in matters applicable to both mechanisms? Okay, so if I understand this, it might be because in some countries, and I think India, if I'm not wrong, is one of the countries. This question comes from a gentleman from India. I think in some countries that they actually make a distinction between a concept called conciliation and a concept called mediation. And the problem with this distinction is that these terms themselves are interchangeable depending on what label you want to put on them. I don't think there's an internationally accepted or agreed definition of what mediation is, and likewise for conciliation. And in different jurisdictions, you may get different interpretations of what one term or the other means. So that's part of the problem. In that jurisdiction, if you say that there's a convention on mediation, then the question is, so what happens if I want to go for conciliation in that place? And I think that although you may say, so what really is the difference between conciliation and mediation? It can vary in many ways. For some jurisdictions, it could be the role of the neutral. Do you just facilitate the process, but you stay silent as to the problem solving and solutions, or do you actively participate in the problem solving? Do you sort of like join in and chime in with your own experience? Do you have any kind of power to sort of tell parties to look, if you're not going to come to an agreement on something, right, then I'm just going to put something on the table and then see what happens. All these things are nuances of how you practice it. Is it evaluative? Is it facilitative? Is it transformative? All these different ways of practicing mediation. So in some jurisdictions, they try to separate these by calling one conciliation and one calling it mediation, but they're really just different forms of the same thing. In that sense, my personal interpretation of what the convention was meant to cover is actually everything in that entire spectrum, the whole gamut. But I do understand that people may say, well, since you didn't explicitly mention conciliation, I have to assume that the convention doesn't cover it, and that could be a problem. So I think what would happen is that in the respective jurisdictions, they need to find a way to sort of bring the convention into that area by using their own domestic legislation, their own enabling legislation that explicitly mentions that conciliation is referred to or covered by the convention and so on and so forth. And that really is why some countries might take longer than others to ratify, because the nature of their own systems requires different kinds of legislation to actually effect the convention properly. So the short answer to yours is, your question is that it unfortunately will vary from country to country, how this conciliation mediation split would then relate to the convention itself. But my understanding is that the spirit of the convention is that it's meant to cover both types. So the country concerned should properly try to find a way to bring both under the umbrella of the convention. Yes, okay, so next question. Is mediation binding for the countries that had ratified the convention? Isn't this a good way to promote other countries to ratify to the convention as well? I'm not quite sure what you mean by is mediation binding. If you mean is a mediated settlement, something that the country, a signatory country that's ratified it, are they obligated under the convention to enforce a settlement agreement from another signatory country? Then the answer is yes. In that way, it's binding on them. They have to enforce it because it's a treaty obligation. But are they bound to use mediation? Then no, obviously, because mediation is a choice, it's a tool. So parties are free to choose mediation, are free to put it into their mediation, clauses in their contracts, or they cannot use it entirely. So I think I'm not quite clear what you are asking, but if it's must they enforce an agreement that was mediated in another signatory country, then the answer is yes. Hi, what do you think about compulsory mediation to pursue before litigation for some certain subjects of disputes in some countries? Yeah, so this is always the controversial question. Compulsory mediation or mandatory mediation, if you will. I guess it comes down to, first of all, a few things. One is, what kind of dispute are we talking about? If it's a dispute in which there's, in my opinion, very little emotional content, very complicated issues of law, then you shouldn't force parties to mediate, because you can't, as I mentioned, you can't mediate out of what the law is trying to say. And if parties are very rational, very even-handed in their negotiations with one another, and they still struggle to figure out a solution that works, you shouldn't force parties to mediate. It may be better just having someone, a neutral, decide, whether an arbitrator, adjudicator, or a judge decide, and both parties can then go back to their own boards and say, look, this is the decision that was rendered, we just have to comply by it, rather than they have to face their board, who will then grill them and say, hey, why did you give away the house? Why did you agree to this? And so on and so forth, right? So in some scenarios, you may not want to force people into mediation. It has to be a choice. And then there's the other part where if parties feel compelled to go for mediation, they may not do it with the right spirit. They might not go in with good faith. They might not go in, wanting to try to really put something on the table that they think the other side might agree to, but they just dig their heels in. They might just dangle a ridiculous offer, a take it or leave it offer, and it sort of, jeopardizes the mediation right from the beginning. So you don't want that. You want people to go in with a certain amount of this was my choice to step into this room, and hopefully that leads us to a positive outcome, rather than, the court forced me to do this. I'm just going to be here, when the time's up, I just want to tick the right boxes and I'm going to be back in the courtroom. So you don't want that. That's not helpful to the process. And it also damages people's impression of mediation if they feel that it's a compulsory process. On the other hand, we also know that sometimes people need to be brought to the table before they will take mediation seriously. That actually their case is one where it's actually very good for mediation. It's actually very appropriate for mediation, but because of one reason or the other, they're reluctant. And that means that you may want to put them through the process of having to try mediation, and along the way they change their minds. We've seen a lot of cases of that sort where there was a certain amount of them being either compelled, or they felt obligated because of certain kinds of clauses that were in their contracts to go for mediation. They went in with a very negative mindset. They went in with a certainty that they will be out at lunchtime with nothing in hand, and yet they stayed to the end, and they found the mediator very good, very experienced, and eventually they came to a settlement agreement. So I think that there's also the counter argument that sometimes you might need to put parties through it simply so that they understand that it is actually a good tool, regardless of whatever their preconceived ideas were before that. And some of the examples of this is in family disputes, like in a divorce case, when you have parties who are very aggrieved, and they don't want to talk. They don't want to have to try to make any concessions to the other side. The pain goes very deeply. So what they really want is, first of all, someone to decide, and secondly, they want someone to scold the other person. I want the judge to say that my husband has been terrible and therefore I should get the house, or something like that. There's this sort of vindictiveness inside that process that leads them to want to go before a judge. And yet, the mediation is actually the single best process, because why would why would a judge be the best person to decide when is the best time for you to see your son, your daughter? What would be the best arrangement for them in terms of custody? How should the assets be divided? Who all these things, in a terrible sense, it's because the parties can't talk anymore. That's why someone else has to make the decision for them. But they are still, at the end of the day, the best people to make a decision and come to an agreement, even if they decided that the marriage shouldn't continue, even if they decided that they can't live with one another anymore. They are still the best people to finally come to an agreement about what's best for the children. So in that case, you may need to say, look, I don't think that you should be allowed to step before a judge until you've had a chance to go before a good mediator. And hopefully you can come to something that works best for everyone involved. And I think that's one of those arguments, which is why in certain segments, countries are more willing to impose mandatory or compulsory mediation, but in certain other arenas, they say, no, I think, these are two companies, they're very commercial minded, they're very experienced. There's no point forcing them through it. They've already weighed all their options and they want to go before an arbitrator, then so be it. So I think these are all the things which we must weigh, that there probably isn't one single, answer that applies to everything across the board. Hi, Anil. Anil says, on the question of whether online mediation may work with the SEM, I spoke about this point last week. My apologies, I didn't manage to catch that. As long as the online mediation was carried out in the framework terms of the SEM articles, then enforcing it if the need arises should be fine in the convention country. So anyway, let me just do a plug here. Anil, who was speaking on this topic previously, is a lot more familiar on this issue. So go and watch his stuff and touch base with him directly if you want to ask more questions on this specific point.
And for those who weren't able to attend last week, the video of Anil's presentation is now online on the IMI and on the SIMI website. So do check it out.
Thanks, Laura. Aren't retired judges whose experience is in adjudicating disputes, who are fast-tracked in mediation training, not a preferred choice compared with more experienced mediators who may be passed over by the centre appointing the mediators? Now, that's a very interesting and slightly pointed question, if I might say so. Let's just put it this way. We actually have many cases where the parties themselves request former judges to be the mediators. It is not the centre appointing the judges. It is the party saying that I would like a former judge, or in many cases, they ask for a specific mediator who was a former judge, because they feel that this person has actually got a certain amount of gravitas and standing in the industry to be able to be respected by both sides. We've had cases where the parties, or one of the parties, requests for a former judge precisely because they feel like the other side has counsel that is being very difficult, being very unreasonable, and not willing to sort of, I mean, it's fine if you're just going for a litigation process or arbitration where your job as counsel is to put the strongest case forward and to rip the other person's case to pieces. But in a mediation, you don't want that. You don't want the counsel to be obstructive, difficult, abusive even. You want someone to say, okay, fine, since we're here to attempt to reach a solution, I'm going to tone down, I'm going to ratchet down that side of me. So we actually see parties requesting former judges precisely because they need someone who can put the other person in his place and say, look, hey, calm down, don't raise your voice. Can we just talk through this, like grown-ups? So I have to say that whether or not you have a view that a retired judge is the best mediator, I would actually beg to differ in many cases because we've seen their skills. I'll be very clear, not every retired judge makes a good mediator. But it is also not fair to say that just because you were a former judge, you are therefore a poor mediator. Because I would make the same argument that what therefore makes a good mediator. There are people from all walks of life who could be good mediators. We have seen good doctors who are mediators. We have seen, engineers, architects, ship captains who make good mediators. I would even argue, based on that particular comment, a dispute lawyer is probably a poor choice for mediation. So all dispute lawyers shouldn't be mediators because their main job is to be aggressive, isn't it? Right? So I think we need to be careful that we don't pigeonhole people based on whatever their experience was, and to look at them as individuals. Some of them, no matter what their practice was, will make good mediators because they make the effort to understand what it takes to be a good mediator. They practice, they learn, they take feedback humbly, and they try to improve. And there are people who are not good, whether they're retired judges, whether they're lawyers, whether they're from other walks of life. So we should refrain from having a blanket comment of that sort and just recognize that in certain scenarios, parties themselves ask for lawyers, parties ask for judges, parties ask for certain kind of background, and the centre just obliges. Do you think that the provision in the domestic contract and subcontract should do away with mentioning the name of a certain institute of mediation body or bodies to handle mediation. For example, in the Singapore in the public sector form, it provides for any mediation to be conducted by the Singapore Mediation Centre. Well, you're asking the ED of the Singapore Mediation Centre whether people should put my centre into their forms. So I don't think you should be surprised that the answer should be, well, of course I'll say yes. But on a more basic point, when parties put a particular institution into their clause, that's their choice. This question was actually raised in Parliament regarding public sector contracts, and the Minister for Law answered the question that it's up to the individual ministries to decide what they want to put into their clauses to a certain extent, or as the government as a whole to make a view. And if there is a centre that they feel that they can trust because of a certain track record, because of a certain credibility that has been earned over time, then why should you forbid people from putting a particular institution in there? It's the same way people would say, I want to arbitrate under the auspices of the rules of this centre. You know, whether it's the Singapore International Arbitration Centre or ICC or the American Arbitration Association, they have expressed a view that they want this institution to pick the neutral because they trust the track record and the, you know, the credibility of this institution, the impartiality of it. So that's a choice of parties. No one's forcing them to have to put it in. They can equally say, I just have a general mediation clause. They can just say, well, I just want you know, to leave it for that time when the dispute arises and we can talk. You know, there's a reason why people want to put in an institution as the appointing authority. It's a very important reason that people shouldn't overlook. It's because when you actually have a dispute, there's a good chance that you can't even agree with the other side about who the neutral ought to be. So you sort of are in a bind because you need to resolve a dispute, and yet you have a new dispute brewing, which is I can't agree on a neutral. So that's why at a point when everybody's still friends, everybody's still, you know, clinking the champagne glasses, you want to block in who is going to be your appointing authority. And you could say that, well, technically there's a number of good institutions out there. By all means, pick one of them, but be careful about picking several, because then you end up with another set of problems, because which institution then becomes the one that appoints a neutral? You then end up fighting over that choice. And believe me, parties who are in the wrong, you know, they breached the contract, they don't want to fulfill the obligations, they will look for any way to stall the process. They'll look for any way to sabotage the process. So if you give a clause that is poorly worded, one party can just basically just stonewall you by continuing to disagree with whatever choice you pick. Like, oh, I want this institution out of the three that we named. No, I would rather this one, or whatever. So you don't want that situation. You want clarity, you want certainty. So that's why you've got to pick an institution. So if you're going to pick SMC, then when the dispute arises, we immediately step in and we appoint a neutral and you can move forward. If you want to pick some other institution and put in your clause, by all means. All we're saying is don't leave the clause too vague. Otherwise, you end up with a secondary dispute in the middle of your primary dispute. Okay. Wow.
Okay. Well done. Yeah, you managed to get through all of them, and then Marcus and I will sort of try to assist in the background as well. So thank you very much for your expertise and your answers to these questions. Thank you as well to the audience for asking such fabulous questions and attending. But yes, thank you, Jiun Ean, and we hope to speak with you again soon.
My pleasure. Take care, everybody. Stay safe.
All right. Bye, everyone.
Bye.